Judgment in the matter of an application by JR222 for judicial review.
Lord Stevens will explain this judgment.
I commence by stating that this court has ordered that no one shall publish or reveal the name or address of JR222 or publish or reveal any information which would be likely to lead to the identification of JR222 or of any member of JR222's family in connection with these proceedings. The appeal in this case concerns the decision made by the then Minister of Health, exercising his discretion under Section 13, subsection 1 of the Inquiries Act 2005, not to suspend the Muckamore Abbey Hospital inquiry until the determination of criminal proceedings against JR222. JR222 is a former staff nurse who is charged with criminal offences in respect of alleged abuse of patients committed in the course of her employment at the hospital. She is presently awaiting trial. The terms of reference of the inquiry are to examine, amongst other matters, the issue of alleged abuse of patients at the hospital. Section 13, subsection 1, gives discretion to the Minister to suspend an inquiry. In exercising that discretion, the Minister decided that it was not necessary to suspend the inquiry for the determination of the criminal proceedings against JR222. JR222 brought judicial review proceedings to set aside the Minister's decision on the ground that on the true construction of Section 13, subsection 1, the Minister had incorrectly applied necessity to the decision to suspend for the purpose of allowing for the determination of criminal proceedings, rather than only to the period of suspension. The Minister submits that the word necessary in Section 13, subsection 1 qualifies both the purpose of suspension and the period of suspension. If that construction by the Minister is incorrect, then the Minister's decision should be set aside. The High Court and the Court of Appeal dismissed JR222's challenge, holding that the Minister correctly applied necessity to both the purpose of suspension, in this case to allow for the determination of criminal proceedings, and to the period of suspension. JR222 now appeals to the Supreme Court, which unanimously dismisses the appeal for reasons set out in a judgment given by me, with which the other justices agree. Section 13, subsection 1, naturally reads as one question, which must be considered as a whole. Therefore, necessity applies both to the purpose of suspension, in this case to allow for the determination of criminal proceedings, and to the period of suspension. I will briefly summarize some of the reasons for that construction. First, the construction is consistent with the meaning of the words used by Parliament. Second, the construction is confirmed by reference to the legislative debate, which is admissible as the conditions set out in Pepper against Hart are met. Third, this construction is supported by the statutory purpose of an inquiry, which is to address public concerns. It would be contrary to that purpose if an inquiry were to be suspended unless it was necessary to do so for one of the purposes set out in Section 13, subsection 1, in this case for the purpose of allowing for the determination of criminal proceedings. JR222's construction would result in delay to the public interest being served by an inquiry in circumstances where it was not necessary for the delay to occur to allow for the determination of criminal proceedings. Fourth, JR222's submission that Section 13.1 involves two stages, with necessity only applying at the second stage, would lead to the illogical result that a stricter test applies at the less important second stage of deciding the period of suspension, rather than at the more important first stage of evaluating whether the inquiry should be suspended. Fifth, the explanatory notes to the Act also point towards this construction. For those and other reasons, the Minister's decision was made in accordance with the correct construction of Section 13, subsection 1. Therefore, the Minister's decision stands and the appeal is dismissed.